Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing the financial economics behind corporate employers lowballing severance when they fire their employees. And what we're focusing on is how the economic models work and support this prospect. It's done in economic modeling, insights, analysis, and information, and is not specific to any one particular company or one particular situation. Instead, it takes a look at how this whole process has come to be and why, based on an economic modeling aspect, the decision of far too many corporate employers is to not offer the full amount that the court jurisprudence would suggest would be applicable. But instead, far too many of these corporate employers decide we're going to lowball and offer substantially less than what is mandated by the courts, knowing full well that to achieve that court-mandated number, you have to go through years of litigation, and the individuals that they're dealing with are in a very difficult position, having just lost their job, not having any financial resources, and thereafter having to find lawyers who are willing to foot the bill for potentially years and potentially be on the hook for a considerable amount of time and money that they might never ever recover just because of other aspects dealing with settlement and the prerogatives of many of these corporate employers to make the situation very difficult, very time-consuming, very costly. Now, we're not necessarily going to go into the strategies to deal with this. That's what we deal with in other videos as well as our own legal practice, because that's highly specific, and much of the stuff that we do is very particular to the jurisdictions that people are working in. But what we're going to look at now is we're going to look at an example. And our example is going to take an economic modeling system of 100 terminated employees who are fired. Not necessarily at the same time, but over a period of time. And for sake of computations, we're going to say on average, those individuals will be entitled to a maximum payout on severance of $50,000 based on what the court jurisprudence would be in this scenario. Now, it doesn't mean everyone's going to be entitled to $50,000, but it is what we use for an averaging. But once again, to achieve that, in most cases, one has to have all the right conditions and has to go through a lengthy court process at considerable cost to either themselves or to a lawyer to achieve that result. So, taking this $50,000 number as your top end number, corporate employers will all too often offer something far less. So let's say our initial offer is $10,000. And that $10,000 offer is made to those 100 terminated employees. Now the reality is, and this is actually possibly lessening the situation, 80 of those 100 terminated employees take that deal. So it only leaves 20 employees. Now, of those 80, some very well might have gone to talk to lawyers and seen that the costs associated, the time issues associated with it are going to be too long and too challenging for them to bear. They just want to move on, take on their next job, and hopefully find another job. Problem is, especially in today's economic situation, finding those next jobs are not necessarily easy, or finding them at a comparable pay level is not going to be that easy. Nevertheless, what we see is about 80 to 90% do simply move on. But we're going to use a figure of 80. Of the other 20, the first step is typically to get a lawyer, or sometimes themselves, to send a demand letter over to the employer, citing a whole bunch of case law, asserting that they are entitled to something closer to that $50,000 number, maybe in excess of $50,000. And that's put forward requesting it of them. Now, depending upon which law firm is sending out the letter, and if it is even a law firm, the employer might then come back and increase their initial offer and say, okay, not $10,000. We're now offering on average $15,000 as a payout. Now, what you find in fact is that increase, because this is more of a gambit, a game of chicken, 15 out of those 20 will potentially accept that increased offer of $15,000. They'll pay out the lawyer $1,000, $1,500, and the remaining balance will come to them. But they're not prepared to undertake possibly years of court litigation with a considerable uncertainty and consuming time. Of the 5 remaining, they file lawsuits against their former employer. And naturally, right after they file the lawsuits, these are the ones that are seen as somewhat serious to the corporate employer. Yes, now they have to fight a bit, but at the same time, they got to prove their point, and they got to position themselves, and their employment lawyers for the corporation need to position themselves to deal with that. So the offer initially to just deal with those people, close them out, let's say is on average provided at $25,000. Again, this might even be a bit high, but let's say they do increase it to $25,000. From that, 2, potentially maybe more, accept that increased offer, and 3 proceed, which is actually a very high figure out of 100, but let's just go with it. Meanwhile, 2 more over the course of document production, questioning, motions, and all those other fun things that take a year, 2 years, if not more, to go through, find themselves going through all these steps, and they stretch it out. And at various times, the corporate employer provides new incentivized settlements. They might not, but let's say they do. And on average, those new settlement offers, let's go with a high-end number of $40,000. So of the 3, 2 more take those offers at varying points, with 1 saying, well, I want to go to trial. Well, they move towards trial, and then the stark realities come to hit in as to where they stand, because the corporate employer wants to close these people out. They're pestilence. They talk too much. So they put in their final offer. Might be $50,000, might be $60,000. And these numbers might even be higher than what would be expected, but let's say that it is. The rationale behind this is that it's going to close out the situation very, very quickly. Because when you think about it, your high water mark already was $50,000. And now they're offering that same amount, if not more, so that it's next to impossible, although there's a potential for it, to exceed that number. And if they don't exceed the settlement number that has been put down formally on paper, what could very well happen in most jurisdictions is from that point forward, the former employee could have to pay the legal fees for the corporate employer. So not only are they going to be on the hook for their own lawyer's fees, but for the pre-trial work and the trial work, they could find themselves having to take whatever settlement number or whatever award comes out of it and pay it back to the employer to pay their law firm, which could easily run $15,000, $20,000. So the pure economics of it is that if they don't take that offer and they go to trial, and even if they win, but they don't win by some grand number of $100,000, $150,000, which is highly speculative and highly improbable, given that the judges just want to focus on what is actually being lost. Then, at the end of the day, when the numbers are all counted up and all the lawyers are paid out, that individual could find themselves with $20,000, $25,000 in their pocket after all these years, when very well they could have had a $50,000 or $60,000 settlement, even though they have to pay another $15,000 or $20,000 to their own lawyer. So the economics from the perspective of that final holdout employee just does not make sense. And the lawyers realize that too, because the lawyers want to get paid. And they worked so hard. They say, look, I'm not going to go put in another $15,000 of my own time, only to have my own costs cut down substantially, my own payday cut down substantially. So, setting aside our other strategies and how things are moving in a new direction, let's focus on what these financial economics really mean and how it is very lucrative for the corporate employer to take this hardball position when it comes to severance. So, we had 100 employees terminated over this period of time. 80 of them accepted the initial offer. So yes, the acceptance costed the company $800,000. But to have fully paid those people out at the $50,000 level, it would have cost them $4 million, such that there is a $3.2 million cost savings on those individuals. Now, with respect to the individuals who had demand letters sent out on their behalf and who had an increased offer come back to them, their acceptance cost the company $225,000. But at full price, it would have cost the company $750,000. Yet again, $525,000 savings for the company. For the two individuals that filed a lawsuit and almost immediately accepted an increased offer of $25,000, their acceptance cost the company $50,000 on a full payment of otherwise $100,000, thereby saving the company $50,000. Now, the two people who held out a bit longer, on average, let's say they did $40,000, still the company would have had to pay $100,000 if they'd gone through the whole litigation process and there was no issues with respect to legal fees and the like. Net saving, $20,000. Finally, that one individual who held out to the eve of trial and found themselves in the position where they got an offer that was, let's say, higher than what was possible just based on a pure severance situation, not any other additional factors of pecuniary or exemplary damages being awarded, as it tends to be the case in very many employment cases. So that person was receiving $60,000 on a $50,000 base full average, meaning that the company lost, in effect, an initial $10,000. But now that we look at all the numbers for all those 100 terminated employees, what we see is that the company had effectively paid out $1.215 million, which is still substantial for 100 employees. However, had they gone from the outset with simply paying out $50,000 as a top-level court jurisprudence, they would have paid out $5 million comparably. And what does this mean? Well, that means there is a net saving of $3.785 million. So what happens is the company is in effect on this economic modeling only paying out 24.3% of the full court severance that could have been achievable based on case law, and has a net savings of 75.7%. So, somewhere with respect to only 1/4 of the top level number is being paid out, even though there's those pockets of individual people, and even showing through our economic modeling and financial analysis, these numbers might be even skewed even more than we would expect. It might well be that only 2 people go on beyond the demand letter phase out of 100. Nevertheless, as you can see, the numbers are very stark. The financial realities are very clear, and the savings are significant, because there is also the waterfall effect that once you start paying out severance at a far higher level, all the current employees know from the former employers how much is being paid out, and they jump on the bandwagon and constantly are demanding comparable levels of payment from those employers. And given the fact that it is the corporation's money and not necessarily the individual shareholder or director's money, they're willing to fight it with their lawyers as a cost of doing business, because the economics prove out that it is advantageous to fight and not to settle out early. Because when you're talking about a 75% or greater savings of taking a lowball position when it comes to employee severance, there is a lot to be said about that. Now, there are strategies to be dealt with on this, and there are other issues from depending on the jurisdiction within which the employee is employed, that could increase the situation. But an overall financial economic modeling of this, it makes a lot of sense for far too many employers to lowball severance. But that is only the first step. And how you deal with it, that is the next step. But you have to understand this, and you have to understand the rationales behind why employers do what they are doing. Thank you.